Yes.
My lady, my lords, I wonder if you'll forgive me starting in this way, whether it might assist to provide the court with, as it were, our headline response to my Lord Justice Moylan's 5 points raised before the short adjournment, although I'm not sure I can promise to be quite as fleet of foot with my oral submissions so as to ensure that they will fit into those categories neatly, but I shall do my best.
Thank you. I think that would be most helpful.
Point 1, jurisdiction for care proceedings. We submit presence or habitual residence. If the Hague Convention applies and habitual residence is in a contracting state, then the contracting state of the child's habitual residence has the jurisdiction. Does the Hague Convention exclude any domestic jurisdiction? Otherwise,
slow up slightly.
Sorry.
Yes, sorry. Presence or habitual residence. If it's at contracting state, you said?
If a contracting state turns out to be the state of the child's habitual residence, then that contracting state, whether it be the child present here, and therefore this state, or whether the child is present here but habitually resident in another contracting state, it is the contracting state.
Matters not, it's the contracting state. Yes.
Question 2, does the Hague Convention exclude any domestic jurisdiction otherwise provided? The answer to that we submit is yes, but only in relation to the example of a competing Hague contracting state. Insofar as Article 5 is not engaged, then there is nothing within the Hague Convention expressly, certainly, nor we say by implication, that excludes the jurisdiction that otherwise exists based on the child's presence within the jurisdiction of this court. So if I'm just considering the position of a child present but not habitually resident, and not habitually resident in any contracting state, then presence remains a good jurisdiction.
Yes, and you would add to that the inherent parens patriae jurisdiction.
I would.
Yes.
Yes.
So any other domestic.
Domestic jurisdiction.
Yes.
Yes. Yes. Forgive me. I'm focusing for the moment.
Don't worry, I
on
understand
section
that. I just
31. The date for determining jurisdiction should be at the start of proceedings. So that, for instance, in this case, if it were the position that the child was not habitually resident at the inception of proceedings, and that seems likely, though I will come on to a factual dispute that was alluded to earlier, which perhaps just raises a question mark, but no more than that. But let us assume the child was habitually resident in Tunisia at the issue of proceedings. Had the court asked itself, does it have a jurisdiction, and if so, what? The answer would be yes, it has a jurisdiction based on the child's presence, and proceedings could have gone forward on that basis. I appreciate we don't have that clarity, or didn't have that clarity, but I appreciate that wasn't the clarity we had as it happens in this case. But if I could turn the clock back, that's what I'm saying should happen, or should have happened. Question 4, what happens if there is a change? So a change of habitual residence. And there, the question we say must be, is that a change of habitual residence to another or to a contracting state? So in our case, child is habitually resident in Tunisia, not therefore habitually resident in a contracting state, but at some point became habitually resident on the learned judge's findings within this jurisdiction, what we say there is that by that point, these proceedings would have been ongoing on the basis of presence. And that therefore, there was no need, or there would be no need, to secure an alternative parallel jurisdiction based on the now habitual residence within the court's jurisdiction afforded to it under Article 5. But it might choose to do so. So our submission is there is a choice to be made. So to use this case, the facts of this case, as an example, if matters had proceeded as they ought to have done, on the basis of a substantive Section 31 case, based on presence, then depending on where the incident of habitual residence within this jurisdiction, where along the line it arose, the court would then have a choice as to whether to investigate and determine habitual residence. So it might be, if things had gone very swiftly, which could have included a return to a relative abroad, if things had gone swiftly, then the child may never have developed habitual residence here. If things are taking a long time, then she might have done. And then we say there's a question for the court. You have jurisdiction based on presence. You have been running a properly constituted, firmly based Section 31 proceedings. But now the child's habitually resident here. Do you have to undertake that investigation and from that carve out the additional jurisdiction under Hague? And we say you don't. However, if, let us say, one was dealing with a child who came before the courts in this country and was, as an interim measure, placed with a relative in a contracting state, and for whatever reason, before the care proceedings concluded, that child became habitually resident in the other contracting state, then Article 5 binds the court. And so we do say at that stage, where there is an apparent change, the court is obliged to investigate because it's a competing contracting state. Now, just to take an extreme case, proceedings might have been afoot for many months. The final hearing might be upon us, and suddenly it transpires, it appears obvious the child is habitually resident in France, for instance. Well, of course, this court would have, under Hague, the ability to open to it, I think it's Article 9, to make a request of the French authority to say, well, we've come this far with the child. This is the plan for the child. Can we finish? To put it in a colloquial term. So it's not, therefore, necessarily a problem. And so we would say that the court does have to look at change in this jurisdiction because we are a contracting state. But if the alternative state is a non-contracting state, then there's a choice to be made. Now the choice might be, for example, again in this case, where the foster carers travel on their holidays to France. Unfortunately, this child doesn't have a passport. But for the moment, if she had a passport and she wanted to go on holiday with her foster carers, then it might well be that the court, if it had a substantive jurisdiction, would express that so that it would be recognised when the child travels to France and there'd be no hiccup were there to be an issue raised by anybody. Similarly, if the child was not habitually resident here and this court was exercising a jurisdiction based on presence and the child wants to go on holiday to France, then again it might be a precaution to make an order under Article 11 expressing the interim care order as an exceptional, as an urgent measure, so that again that would be recognised in France and there would be no difficulties in the foster carer exercising parental responsibility on behalf of the local authority.
Now, I know it isn't this case, but if proceedings are started and there is no jurisdiction, sorry, let me start again. I'm thinking of the Mrs Justice Leaven case. So proceedings are started at a time when the child or children are habitually resident in another contracting state, but become habitually resident here during the course of the proceedings, because they take quite a long time. What do you say the court has a choice there? What do you say? I know it doesn't arise in this case, but just as a matter of interest, what would your submission be in that situation?
Our submission is that the text of the convention, the supporting explanatory report and practical handbook, and indeed a reading of the CJU case that's in our bundle of the child who ended up in Russia, would lead one to say that as soon as the court appreciates that habitual residence has shifted, it is obliged to see jurisdiction, although at the same time it might make a request. Sorry, I've got it the wrong way around. As soon as the court becomes aware that the child is now habitually resident here, then it must say, we have jurisdiction, but it might at the same time suggest, under, I think it would then be Article 8, that the proceedings are transferred.
It's not the proceedings, as Mr Setro pointed out, it's jurisdiction.
Well,
and the thing is, at that point, and this is where maybe we shouldn't go into it in this case because it doesn't arise, at that point the other state doesn't have jurisdiction.
No.
Because the habitual residence has moved. So it's quite a tricky, and that's why this question of the change during the course of the proceedings actually throws up quite a number of potential difficulties.
Yes, it does. And in this particular case, one of the difficulties is potentially a matter my Lord referred to earlier, and that is the busy state of our family courts. For if, for one thing, the family courts need to know whether there is this residual, well, it's called a residual, whether there is a substantive jurisdiction based on presence. So, for instance, I think we put the standard...
No, well, that does arise in this case. Because Mr Justice MacDonald dealt with that issue on the basis that there's an alternative.
Exactly, but I think it would be helpful if we're right in suggesting there's a choice to be made where it's a non-contracting state, for the court to say as much, because otherwise one might have a situation where it becomes apparent quite late in the day that there has been a shift in habitual residence, and then the final hearing is derailed, really for no good substantive reason. And that would be to inquire as to whether or not we can have a Hague Convention jurisdiction on top of the presence jurisdiction. Now, it might afford the child, in the particular circumstances of the case, it might afford the child an advantage. So it might well be a child who's travelling to and fro, or is expected to travel to and fro, another contracting state. That's why we say there's a choice to be made. So those are, if it helps, those are our opening submissions. And shall I deal with the arguments in relation to perpetuatio fori and then presence? But can I say at the outset that the appellant contends that this particular child, now present in this jurisdiction for nearly 2 years, the position is that the court does not have a jurisdiction on the basis of the proceedings currently before it. I think what is suggested is that there might be a withdrawal or dismissal of the current proceedings. But we say that cannot be right. And in the course of my submissions, I will refer to the child neutrally in that way. But of course, the court will be only too aware that this is a child who has suffered, as many, or indeed all, are suspected to or thought to have suffered when they come within the sphere of Section 31 proceedings, significant harm. So it is as well to bear in mind that one is dealing with a particular cohort of children. And this child in particular, at a very early age, lost her mother. And before that had been in a children's home. And after that, before she lost her mother, had suffered some neglectful parenting. And this child has lost her father to imprisonment, and then perhaps more generally lost touch with him. And she spent some time in the care system, and there's a question about whether or not she was sexually abused. And she shifted her whole home from France to Tunisia. And then she came here in circumstances which, frankly, are not clear. And may I just deal with, address that point, because it's only a small factual point. But it illustrates the difficulty that the family court might face in a Section 31 case in dealing with issues of habitual residence. The paternal uncle, and my lords, it's page in the core, in the supplemental bundle. It's his witness statement at page 104. And my lady will see at 104, the bottom of the page, paragraphs 18 through over to the next page, 21, what he says about how it was the child came to this jurisdiction.
Sorry, what paragraph?
Paragraph middle 18, 19, 20 and 21. Now that is a factual dispute, and that's apparent from the way in which on behalf of the grandmother identified the circumstances of her arrival in the jurisdiction. But without wishing to go into the detail of how one assesses the habitual residence of a child, clearly intention of those with parental responsibility or around the child is important. In Section 31 care proceedings, the requirement to undertake an habitual residence inquiry will necessarily depend in large part on those closest to the children. And those closest to the children, by dint of the institution of the Section 31 proceedings, are suspected to have caused significant harm, or the child in their care is likely to suffer significant harm. And so it follows from that, firstly, that unlike the private law dispute, there is not a case at one end of the spectrum contested by the other parent at the other end of the spectrum. This was our intention, no, this was our intention. You have a joint approach by those around the child, the parents. And so the court's inquiry is made the more difficult. The court would want all the more to look at independent evidence. Independent evidence would come ideally from the state of origin. In a non-contracting state, that is difficult, potentially, depending on the state, but one can foresee many states where that would be difficult or even impossible. And then, of course, the court has to listen to the evidence and choose which account it accepts, or indeed might have to try and divine whether there is something that happened that has not been spoken. So in other words, it is a complex approach in a Section 31 case as opposed to a private law case. And this case was listed for 4 days, I think it was 4 days before Mr Justice MacDonald. Now, in the High Court, those days are precious. In any court, 4 days are precious. And in fact, what would a local authority in this local authority's position, what would a local authority's position be faced with that account from the uncle and a contradictory account from the grandmother? I mean, if these matters are to be required of the family court, that is, an inquiry into habitual residence, even when there is already a jurisdiction based on presence, it's for that reason that we've raised for this court's consideration whether or not, with a non-contracting state, there is that necessity to undertake the habitual residence inquiry. So the contextual approach to Hague and perpetuatio fori is firstly, habitual residence, being a factual issue, is necessarily susceptible to change. If habitual residence does change, then Article 5.2 is explicit. So if it is the case, pursuant to Article 5.2, that in the case of a change of a child's habitual residence to another contracting state, how could a contracting state, knowing that the other state is now the state of the child's habitual residence, properly conclude that it has still jurisdiction? If, in the course of proceedings, let us say a convention country, where a child has his or her habitual residence, proceedings are issued, and subsequently habitual residence shifts to convention country B. Well, if in the course of proceedings the court in country A asks itself, is this child habitually resident within the jurisdiction, and is obliged to answer no, then is it not similarly advised to say that if that child is habitually resident in convention country B, then pursuant to 5.2, that country must have the jurisdiction? Now, in their skeleton argument, in her skeleton argument, the appellant, I think at paragraph 28, indicates that jurisdiction could be kept under review. But of course, if it is kept under review, a review is meaningless if those questions are not asked, the questions about habitual residence. So we say, that's why the learned judge was correct to say that had there been an express provision otherwise to counter the effect of Article 5.2, then based on an initial seizure of the proceedings, as there is in Article 8 of the regulation, but in the absence of that, then the ordinary meaning, the ordinary and natural meaning of Article 5.2 is not defeated. Lagarde is clear in the explanatory report, and the reference is the internal page is 553, and my lady and my lord's authorities bundle, it should be page 54.
Page 54.
54.
Thank you.
I hope page 54 is internally on the Lagarde report 553, and the right-hand column halfway down turns to paragraph 2, and the second paragraph beginning the change of habitual residence. The change of habitual residence deprives the authorities of the form.
Yes, got it. Thank you.
Yeah. So that is clear. And we say that is consistent with another article within the convention, and that is Article 15.3. And the convention is at the start of the authorities bundle. And 15.3, page 7 here.
Sorry, page 50.
So it's Article 15.3, page 7 of the authorities bundle. Article 15 is the first article on the issue of Chapter 3, applicable law. And the wording is that if, under paragraph 3, if the child's habitual residence changes to another contracting state, the law of that other state governs, and here we say the words are to be emphasised, from the time of the change, the conditions of application of the measures taken in the state of the former habitual residence. So how could a convention state exercise a jurisdiction over the child when it is apparent the child's habitual residence has changed to another convention state, and from the time of that change, the conditions of the application of the measures of that first state are governed by the law of the new state? That must be a clear indication that as soon as habitual residence shifts, the proper authority is the authority of the new convention state of habitual residence. We have provided, and I'm very sorry that this wasn't provided in the authorities bundle, but I hope it's made its way to the court this morning, 2 pages from the practical handbook, taken from paragraph 4 of the handbook. And this is the passage that deals with Article 5. On page 40b, 4.8, 4.9, dealing with what happens when a child's habitual residence changes. And then at 4.10 on the next page, where the child's habitual residence changes from one contracting state to another at a time when the authority of the first contracting state are seized of a request for a measure of protection, i.e. during pending proceedings, the explanatory report suggests that the principle of perpetuatio fori does not apply, and jurisdiction will therefore move to the authority of the contracting state of the child's new habitual residence. And where it does occur, consideration might be given to the use of the transfer of jurisdiction provisions.
Now, this isn't a statute, but I've always puzzled over that last sentence, because you either do or you don't.
I wondered if that meant that you might have to, but at the same time make a request that it's transferred back.
Could be.
It just seemed to me that
Yeah, so it's confined to that.
that last line.
Mr. Setright's pulling a face.
Well, I have the advantage of not being able to see Mr. Setright's face.
No, I have the advantage of being able to see his face the right way around. Yes, okay. So, but it doesn't confine it to that, does it? But I mean, this is just a practical handbook.
It's a practical handbook.
Yeah, it's not a statute.
No, but it does. It highlights. I mean, what I think is important about the practical handbook is it's a handbook for all the contracting states to have regard to.
Yeah.
And if one is concerned with uniformity, rather, across the many contracting states, there are many contracting states who are not in and may never be in the European Union as a member state. And so, as I suggested to Mr Justice MacDonald, that whilst we've been used to not having an insular British approach to matters concerning children from abroad, there shouldn't be an insular European approach either when it comes to a far wider reaching document such as the Hague Convention. Article 7 is perhaps worth noting. Article 7 deals with abduction. The only reason I mention abduction is the emphasis that's placed by Lagarde in his report, and this is page 56 now of the bundle of authorities. And it's in it's on the left-hand column, the first paragraph, 46, under Article 7.
Not very encouraging, is it? The Special Commission have not been able to reach an agreement on the text, but determining jurisdiction.
No. One or two discouraging aspects of this.
Bit of a gloomy thought, really.
Yes. It's right to say that if one reads into the second paragraph of 46, the underlying idea is the person who makes a wrongful removal should not be able to take advantage of this in order to modify for his or her benefit jurisdiction of the authorities called upon to take measures of protection. It goes on to say, but on the other hand, the wrongful removal, if it persists, is a fact that cannot be ignored to such a point as to deprive the authority of the new state, which has become that of the new habitual residence of the child, of this jurisdiction over protection. So the point that's being made is that even in the case of a wrongful removal, and one can look at Article 7 to see that it is hedged with conditions that would need to be overcome before habitual residence, a shift in habitual residence would be recognised as conferring jurisdiction. And it, just pausing there, that is not, Article 7 is not considered, for instance, in Mr Justice Lieven's judgment, and the mitigating effect of Article 7 on any potential wrongdoer by way of abduction. But the important point we say about what Lagarde has reported here is that it underlines the degree to which the principle that the learned judge below identified at paragraph 107 was correct. So it may be undesirable as a matter of policy that delays could yield jurisdiction, but even in the case of an abduction, habitual residence is so important, and the shift in habitual residence so important that jurisdiction shifts with it. And so we said the learned judge was right to say that jurisdiction with the closest connection on the facts to the child's family and social life is best placed to decide issues concerning the child's welfare. That is what underlies the approach of Hague. And then I think finally in relation to this part and the Lagarde report, there's a reference made by the International Academy to paragraph 42 of the Lagarde report, which is on the previous page of the authorities report. I might have tried to ignore this, but for the fact, because it's not straightforward, at least to me, but for the fact that it's raised by the International Academy. And I think we would say it supports our proposition rather than the proposition for which they contend.
Just give us a moment and we'll try and work it out.
Which paragraph?
Paragraph
behind
42.
you.
So it's paragraph 42,
Page
55.
This is the one that features in the judge's judgment multiple times.
Yes. Yes, it does. So I am at this point particularly interested in the reference to the Commission rejecting, that's about 10 lines down, by a strong majority, a proposal brought by, among others, the British delegation, favourable to perpetuatio fori. And this is the extract that appears in paragraph 17 of the International Academy's submission. And what is emphasised in their submission are the words, in the case of a change of habitual residence from one contracting state to another contracting state, it's not acceptable that in such a situation, which is located entirely within the interior of the scope of the application convention, the termination jurisdiction be left to the law of each contracting state. This is a discussion, this passage, I believe, is a discussion of the two motivations behind those voting down the British, amongst others, proposal. The primary motivation was hostility to the notion of perpetuatio fori. The second reason, the second motivation, distinctly, was that it should be left, there should be nothing said about it, and it can be left to domestic courts. So in fact, when Lagarde refers to the first opinion being more exact, the first opinion is that it's voted, that we should take it, I suggest, that the principle was voted down as a matter of principle, and what is undesirable is that issues are left to domestic courts. And that is why I submit that this jurisdiction should be slow to do anything other than endorse a procedure. My friend says the convention is one thing, procedure is another. But to endorse a procedure that does not sit with Articles 5.2 and Article 15.3, that would frustrate the ordinary meaning of those articles, which is that as soon as habitual residence shifts, then jurisdiction shifts.
Yeah, I'm sure you're coming to this, but just thinking through it a moment, I quite follow that if you start off with habitual residence in contracting state A, and then habitual resident moves to contracting state B, and proceedings are brought in contracting state B, then plainly contracting state B has jurisdiction, because that's where habitual residence is. What happens if proceedings in contracting state A, in contracting state B have been brought earlier, at a time when habitual residence was in contracting state A, and then habitual residence is acquired in contracting state B? I mean, it isn't so obvious that the materials you're taking us to deal with that.
Well, I say on an ordinary reading of Article 5.2, in the case of State B, if the child is not habitually resident there but in State A, but is subsequently to become, then initially it would decline jurisdiction, and jurisdiction would, under Article 5.1, be in State A. Upon the change, jurisdiction shifts.
So if you have proceedings in respect of which the court has not already declined jurisdiction, at a point when habitual residence moves to that state, do you say, look, those proceedings were bad initially, you have to start again? Or do you say, it's good enough that we now have jurisdiction?
The initial proceedings would have been good. So if I'm dealing with the right example, the proceedings are good. So in the State B not having habitual residence, then clearly it would have to decline jurisdiction, and those proceedings would stop.
But suppose that hasn't happened by the time habitual residence is acquired in State B. So initially, when the proceedings are brought, there is no jurisdiction. But there comes to be.
Well, then I think that would have to be a matter for the domestic law of State B. State B would have the jurisdiction, whether it considered it had the jurisdiction under pre-existing proceedings, which it realises now progressed for want of jurisdiction, then it would be a matter for that court, that country, that country's authorities. Just as I say, in this case, it was a matter, if we go back to the summer of last year, it was a matter for Mr Justice MacDonald to decide whether or not, it would have been a matter for Mr Justice MacDonald to have decided if there were clear proceedings based on presence established, whether or not to then additionally bolt on the Hague Article 5 based proceedings, jurisdiction.
But so what you're saying in answer to my Lord's question is that the fact that the proceedings in State B originally were commenced without jurisdiction, the response to that would depend on the domestic law of that state, not on the application of any principles or any articles in the convention.
Yes, I think the response to discovering that you now have a jurisdiction, that you didn't have a valid jurisdiction, but you did have proceedings, that I think has to be governed by the domestic law, because that is a matter for their procedure.
And I suppose it might depend on it's difficult, isn't it? Because, yes, because we're assuming that there were no proceedings at any point in State A.
Because if there had been, one would assume that
an application would have been made to stay in State B.
Yes.
So there's still the prospect of, in a sense, a court retrospectively being vested with jurisdiction, although not actually, by the elapse of time and the acquisition of habitual residence. And I think that's one of the things that's troubled certainly the judges below.
Yes. Well, in this jurisdiction, it's hard to, or it might be easier to deal with a situation, an example in this jurisdiction. I can't immediately consider a situation where a court instituted proceedings, Section 31 proceedings, without any jurisdiction, only to discover later on.
Well, isn't that what happened in Mr Justice Leaven's case? The children were habitually resident, or were found to have been habitually resident in another contracting state at the date of the commencement of the proceedings here. So this court did not have jurisdiction, and there was no residual or other basis of jurisdiction. And then, and I can't actually remember the detail now, did she decide that they had become habitually resident during the course of the proceedings?
I think so, yes.
Right.
Yeah, that's right.
But made a request under Article, say, 8 or 9, probably 9. And so your submission would have been it wasn't necessary for her in that situation to have made a request under Article 9.
No, I mean,
because this court had acquired jurisdiction.
So I think there's a difference between a factual.
So what advantage? I mean, are you gaining an advantage by starting what might be speculative proceedings in a state on the basis of hoping that you'll be able to prevaricate and then vest that court with jurisdiction?
In the case of two competing convention states.
Yes.
You should clearly, if you're true to the terms of the convention, then you should not, because you should immediately or forthwith determine the issue of habitual.
So you agree with Mr. Setright that the issue of jurisdiction should be determined at the earliest possible stage, in particular if there is a question mark about it.
Absolutely, and there probably was sufficient to raise a question mark based on the factual dispute. It might have been dealt with a lot more swiftly, but there may have been a question mark. But
so your submission is to the effect that there are two relevant dates. One is the date of the commencement of the proceedings, and one is the date of the
any subsequent change in habitual residence.
Any subsequent, okay.
Yes, which may or may not occur. And then
so not reviewing it at every hearing sounds a bit cumbersome.
Well, quite how the court deals with that is up to, I suggest, up to the domestic court in each Hague
Well,
state.
here we are. What do we do?
Well, it's rather like those old striking out for want of prosecution applications, where I used to say, "Well, it's been 8 years. When did you lose your memory about the accident?" The habitual residence, if one uses the seesaw analogy, which may or may not assist, it's difficult. I think, put it this way: within the period of the usual 6-month care proceedings, 26 weeks, with a child in care and many children not having enjoyed the level of security this child has, it might well be the case that the presumption would be that habitual residence, if it's not here, will not arise within those 6 months.
Not change.
Not change. But I don't think I can do any better than that. I think it does depend. I think if there's no better person to consider it than the guardian, but it does depend on the parties before the court, and indeed the court. Well, the court, of course, has the obligation to consider its jurisdiction. So I suppose I should start with the court.
Can I just try confusing things for a moment by comparing with ordinary civil litigation? In ordinary civil litigation, if you bring proceedings before you have title, that's no good. The proceedings go. So if you take, say, somebody who, there's been a death, somebody applies for letters of administration and gets letters of administration. But if they bring the proceedings before they've got letters of administration, the proceedings are invalid. They go, that's that.
Yes.
Even though later on you get the letters of administration.
Yes.
So if there were any kind of basis for comparison here, in the situation where you start with habitual residence in contracting state A, which has jurisdiction, and then later habitual residence comes to contracting state B here, the fact that proceedings have been brought earlier wouldn't do, because they had been brought at a time when there was no jurisdiction. So in the situation where habitual residence is in country A, which is not this country, can you nevertheless say there is some residual jurisdiction? Well, I suppose this is another question, such that when the proceedings are brought in advance of habitual residence being acquired, they're not entirely nugatory.
Well, the example I can think of, I don't know if it's a good example, is the situation where a person in this country wants to issue proceedings because although a child is habitually resident elsewhere, wishes to encourage the court in this country to make a request for jurisdiction. Now, the route for that person to come before the court is not entirely clear. Article 9.
But that's not this. I mean, that's quite that's not quite a discrete example.
It's an example of there obviously being no jurisdiction.
But your use is being used for a specific purpose.
It's being used for a specific purpose.
But if it's not being used, to follow up my Lord's question, if Section 31 proceedings are started when there is no jurisdiction, why are those maintained if it's subsequently decided that there was no jurisdiction? In other words, they were, in a sense, invalid from the outset. Well, in a sense, they were without jurisdictional foundation from the outset.
Yes, I mean, they were without jurisdiction.
So the strict legal approach might be said to be you have to dismiss them.
Yes, now that might be an acceptable reason for then issuing proceedings for a second time. What would not, I submit, be a good reason for that would be the invitation of the appellant, which is to park the child, whether in aspic or otherwise, under an Article 11 and wait for the child to accrue habitual residence in the jurisdiction, then to dismiss those proceedings, and upon the dismissal of those proceedings, because the child's now habitually resident, issue new proceedings. That, I suggest, would be, I'm interested it's suggested, because that would not just be arguably an abuse of the process of the court to issue proceedings to park the child until he or she becomes habitually resident, but would be intolerable in the landscape of Section 31 proceedings.
But have you answered my Lord's question as to what the status there is of proceedings which have continued without jurisdiction?
Well, my instinct is that if proceedings are commenced without jurisdiction, that there would need to be new proceedings once jurisdiction has been secured. Can I ask that we consider this and put something in writing just within a couple of days, unless my lady and my lords are going to push for judge. But that is something I perhaps would need to think a bit more about.
It is quite, I mean, because orders will have been made, and it may be artificial in the sense that Article 11, if we're really looking at urgent situations, aren't we? You said we're looking at interim care orders. It may be that there will always have been an article, or can it always be assumed that there will have been Article 11, or certainly the court's attention needs to be drawn to whether it has jurisdiction to make orders and seek to establish that it does. And if it can't find any basis for jurisdiction, then the answer really is that proceedings should be dismissed.
Yes. Well, may we reflect and...
I mean, just following that up, so back to my hypothetical example. Child is resident in country A, contracting state A, not this country. But nevertheless, there's a need to take emergency measures here. So proceedings are brought relying on Article 11.
Yes.
And those have not yet been determined by the time habitual residence is acquired here. That's all right, is it?
Yeah, so an example might be that we're obviously concerned with the person of the child, but it might be the child's property. Under Hague, person and property. So it might be the child's property needs to be secured until proper representation can be put in place for that child to be represented in relation to its property.
Yeah.
I think finally, in relation to perpetuatio fori, can I just ask the court to look at the CJEU case, please? And that, I think, should be at page 492 in the bundle. Sorry, it's not. It's at 398. CC and VO. This is the case of the Swedish child who went to boarding school in Russia, and an issue arose in relation to the distinction between Article 61 of the regulation and Article 8 of the regulation. And the head note, paragraph 1, from a combined reading of the two, it's clear that Article 8 ceased to apply if the habitual residence of the child had been transferred to a third state, which is a party to the 96 Convention, before the competent member state, hearing a dispute, had given its ruling. But if, in fact, the change had occurred after the ruling, then that didn't preclude the provisions from applying for 61B for recognition and enforcement. And in particular, therefore, to direct the court's attention within the judgment to paragraph 33. Bottom 404. Just looking at the previous paragraph, the relevant passage of 61A is set out, where the child concerned has his or her habitual residence on the territory of a member state. That's in distinction to Article 8, which is similar, but says at the time the court is seized. So where the move is before the ruling, the general rule arising from Article 8 ceases to apply. And the reasoning then, and the first reasoning is paragraph 34, and the second, to which I'd like to refer, second reason is that although Article 8.1 of the regulation states, in essence, that jurisdiction in matters of parental responsibility is conferred on the court of the member state in which the child concerned habitually resides at the time the court is seized, Article 61A of the regulation does not contain the same stipulation. So, by way of a shorthand, Article 61 is in similar terms to Article 5. And
is Article 61 in the judgment? Or is it?
It is.
Yes,
yes, it is.
Where is it?
In this judgment.
Yeah.
It is at paragraph 11, page 401.
Yes, I see.
And the next.
Hold on.
Sorry.
So, as concerns the relationship with the Hague Convention, this regulation is about where the child concerned has his or her habitual residence on the territory. So that's what they're focusing on. If the child has his or her habitual residence in another contracting state, then the interpretation of 61A is that the regulation no longer applies. Is that it?
That's right. And there are 2 points we wish to glean from this, or suggest are important from this report. The first is the significance of the distinction between paragraph 61A Article 61A and Article 8, and in particular the absence from the former of what appears in the latter, namely at the time the court is seized, and the consequence of that being that the view of the CJAU was that jurisdiction should therefore shift. And the second important point we submit, again, it's back at page 405.
Sorry, yes.
So it's the interpretation of 61A as it stands.
Yes.
As in distinction to Article 8. And
I see. So 61A is whenever.
yes.
And 8 is at the time the court is seized.
Yes. And so 61A is similar to Hague.
Yes.
And the CJU's view, therefore, of the impact or the effect of that wording is helpful, we suggest, to the proposition that jurisdiction shifts at the point at which habitual residence changes. And then paragraphs 39 and 40, so page 405. (39) The intention not to undermine the provisions of the convention, and paragraph 40 setting out in particular 5.2. In other words, it's not just that the court was concerned to respect the distinction, but that it observes the distinction, and in this case, that distinction led to a significantly different approach.
Where does it say not undermined?
End of 39.
Oh, I see. Thank you. Yes. Yes.
Those are our submissions on perpetuatio fori, unless I can just further. In relation to the issue of presence, I think I should start by impressing upon the court that we are in an ever more globalised situation with the travel of children across borders, more now than ever before. And so it is not uncommon for states' authorities to encounter children from other nationalities and other states. And it is perhaps more common now than ever before. Second point, I suggest, is that the very travel across a border can be a crucial element of the abuse of a child. So I have in mind trafficking, preparation for forced marriage or female genital mutilation, and the well-established rule that there should be no different approach to one child as opposed to another based on nationality. The obligations under Article 34 of the Convention on the Rights of the Child to protect children, for example, from sexual exploitation and abuse is as important for a child habitually resident here as a child who is visiting here. It goes without saying. The same applies in relation to the obligations in respect of, for example, Article 3, to intervene where aware to prevent inhuman and degrading treatment. And so we say it would be surprising indeed if the passage of the Convention into domestic law, a convention which is there to safeguard and promote the welfare of children as one of its stated aims, were to impinge upon domestic jurisdiction so as to remove from the protective jurisdiction of the courts of England and Wales Section 31 proceedings, which have otherwise been established as valid on the basis of presence for many years. We've referred in our skeleton to the obligations that Parliament has placed upon a local authority, and that those obligations relate, for example, to children who are found in their area. We noted that in her skeleton argument, when addressing section 31.8, paragraph 28 of her skeleton argument, the appellant notes subsection A, but not subsection B, and subsection B, we can
So paragraph 28.
paragraph 31, subsection 8 of the Children Act.
No, sorry, you said the skeleton in paragraph 28.
Oh, sorry, the skeleton is paragraph 28.
Is it? Okay.
Sure.
I'll say that anyway.
Not convinced about that.
Forgive me.
It's dealing with delay. You wanted us to turn to the section 31 of the Children Act.
Yes, that's more important.
Yeah.
I'll find the right reference, if I may. Section 31 is at page 27.
Yep.
And section 31.8, it's highlighted at the bottom of 28, page 28. Oh, sorry, so it's page 28 of the authorities bundle. That's where I got my 28 from. I'm sorry, it's the appellant skeleton is 37, which is page 18 of the bundle. The important point to identify is B. So there are two bases, two children who may be the subject of a care order. That is a child where the child is ordinarily resident in the authority. B, where the child does not reside in the area of a local authority.
Sorry, where is it again? 31.
31.8 B. Bottom of page 28.
I've got it. Thank you, yes.
So one is dealing with children under section 47 who are found in the area, and under section 31, orders made in relation to children who do not reside in a local authority area. In relation to the appellant's arguments on the jurisdiction in respect of presence, can I address Article 11? We would say that Article 11, clearly on its face, and this is page 6 of the authorities bundle, must be a case of urgency. And so it is not apt, we submit, for substantive Section 31 proceedings to be begun and completed pursuant to Article 11. Section 31 proceedings are required to consider, firstly, whether the child suffered harm or was likely to have suffered harm. And then, if that is established, the question for the court is, where should the child live, with whom, and under what order, if any? Those are not anything other than substantive issues. So, in our submission, this child arriving from Tunisia on day one of the proceedings, it would be wrong for the local authority to seek to say that it was only establishing its jurisdiction on the basis of Article 11. Now, it might be that provisions made within the Section 31 proceedings, such as an interim care order, in the example I've given of a travel to France for a day trip or a holiday, would then be best packaged, as it were, as an Article 11 remedy. But they are not apt to a full Section 31 jurisdiction. And importantly, Article 11.3 identifies potential issues. So first of all, Article 11.3 makes it clear that for the purposes of the contracting states, the state which is in charge of the situation, if I can use that phrase, is the contracting state. So the measures that might be taken under Article 11, where the child's habitually resident in a non-contracting state, they lapse in each contracting state, so which means that they are valid and recognised within all contracting states because they've been taken by a contracting state, but they lapse as soon as the measures required by the situation and taken by the authorities of another state, so the non-contracting state, primarily I suppose, are recognised in the contracting state in question. So the measures taken are down to the contracting state. The need for those measures continuing is down to the contracting state. So the contracting state is in charge. What that demonstrates, however, is that it's firstly not a full substantive jurisdiction, but it does hold the ultimate power to decide on the sufficiency of other protective measures taken. And it limits the non-contracting state's jurisdiction as a consequence of and in a manner determined by the convention as to which it is neither bound nor a party. If that is the appellant's case, we say it would be surprising if the non-contracting state is bound in that way by a convention it's not a party to.
Well, I think all it's saying is that once measures taken by a non-contracting state are recognised in the relevant contracting state,
yes,
then the measures taken under Article 11 cease to have effect, it doesn't say how they're recognised. They may or may not be recognised.
yes.
But it's saying if they are, you can no longer continue to rely on provisions or measures that really have ceased to have any effect.
Yes, but the important point we say the decision maker is the contracting state that put the measures in place. And secondly, I did wonder what the appellant's case would be about the child who, it's this child, who we are told there would not be a jurisdiction based on presence. Proceedings are instituted. There is no habitual residence, and the habitual residence test is completed at the outset. I'm not sure whether under the appellant's case or when it is then considered again. But if we are stuck with Article 11, urgent powers, then does that mean the child is left until she acquires habitual residence here?
Well, that was the question I asked.
And we have the answer. And that cannot be right. I mean,
The answer being
yes. And then
that there's
dismiss.
just a void. Or
Yes,
aspect, or
limbo, I think, is an old-fashioned phrase. But the child is frozen under Article 11, and I cannot see that substantive welfare decisions, which depend upon assessments.
I'm not sure if that's quite what Mr Setright said. I think with his not conceding.
I think he suggested that Article 11 might continue to fill the void.
Yes, or alternatively, that the non-concession about presence would allow the care proceedings to proceed.
Based on presence.
Based on presence.
That's right, with respect, my lady. There were two alternatives. The second put forward by your ladyship, which I accepted as an alternative, subject to the caveat. I won't say any more at this stage.
My lady, my lords, the Section 1(2) of the Children Act is clear that delay is injurious to the welfare of a child. Part 4 requires proceedings to be concluded within 26 weeks.
But your primary submission is that there's nothing within the Hague Convention, either Article 5 or even Article 11, which suggests that any other domestic ground for jurisdiction is removed.
Yes, in fact, every reference that one can find in, for example, the Lagarde, the explanatory report, there are many references to the survival of the domestic jurisdiction. And one can see those, for instance, at paragraph 84, which should be page 64 of the authorities.
I mean, it's interesting in a way that the Brussels II regulation had extensive provisions that go all the way down.
Yes.
Deal with presence, deal with residual, but the Hague Convention doesn't.
Well, I suspect the reason for that is, and the phrase is used in the Lagarde report, to guard that there was a concern that if it was spelt out, it may be even in this passage.
I think it is.
But the worry about exorbitant jurisdiction.
Yes. Yes.
Whereas that probably wouldn't be a concern within the member states of the European Union. So, for fear of using an entirely inappropriate analogy, the carpet, the regulation is wall to wall. The convention is a rug. Those who stand on the rug are bound by the rug, and the other non-convention states are not. That may not be helpful, judging by my lord's face, but which I do have the advantage of seeing. Forgive me. Paragraph 84 of the report, and I think there may be three points to divine from this paragraph. We of course have drawn attention to it. The complete and closed nature of the system. So just to approach that point I just made from different angle, what does it mean, a closed system? Well, we say closed must mean closed as between the contracting states. But the important passage for the moment that we look at is just the last 7 lines. But these articles, referring there to 11 and 12, these articles do not exclude the broader bases for jurisdiction that the contracting states might attribute to their authorities in application of their national law. And in this case, the other contracting states are not at all bound to recognise these broadened bases for jurisdiction which fall outside the scope of the convention. So,
sorry, I can't find, where's that?
right at the last 7 lines of paragraph.
Oh, sorry, I was looking at the bottom on that in that
Yes.
column.
I want, if I may, just to break this down into three passages. There are 3 points. So that first passage clearly regards identifying the situation where Articles 11 and 12 arise. That's a situation where the children are present in a jurisdiction. Article 11 and 12 apply to children who are present in the jurisdiction. Children, he says, present who require a broader basis for jurisdiction. In other words, meaning something beyond the urgent and not excluding a substantive jurisdiction, and meaning a jurisdiction by the domestic law. We said the point is there is a domestic law. It's recognised as validly exercised by the contracting state, but clearly it's not recognised necessarily pursuant to the convention. It might be that a care order made in this country would be recognised if it were made on the basis of presence, for example in France, but it wouldn't be pursuant to the convention. The second point then relates to the last 2 words on the first column at the bottom. The same thing is true, for even stronger reasons, for the children who do not have their habitual residence in a contracting state and who are not even present in one. The same thing is true means they're not subject to a complete and closed system, and a broader domestic jurisdiction may also be applied. He gives 2 examples. And why are they stronger reasons? Well, in the first example, children who do not have their habitual residence in a contracting state, there's no competition with another contracting state. The domestic court should not be prevented from exercising a jurisdiction permitted under its domestic law by a convention when the state of habitual residence is not a contracting state. And the closed and complete aspect, we say, of the convention does not apply. Third part of this paragraph, the Commission to the end, and it's here in the middle of that paragraph that this proposal, that is, that there would still be national law. This proposal was considered as expressing the correct interpretation, but it was not retained for fear of how it might be interpreted, and there is the reference to exorbitant rules. So it's the correct interpretation but could not be spelt out. The handbook we've referred to, it's in the authorities bundle, I think, at 518. Reference to chapter 3.
So 518.
Sorry, Malay, could we start at 517, please, which is where the paragraph begins. Paragraph 3.12. It should be noted where a child does not have his or her habitual residence in a contracting state, the rules of jurisdiction in Chapter 2 form a complete and closed system which applies as an integral whole in contracting states. Therefore, a contracting state is not authorised to exercise jurisdiction over one of those children if such jurisdiction is not provided for in the convention. And then over the page, paragraph 313, in contrast, where a child does not have his or her habitual residence in a contracting state, the authorities of a contracting state may exercise jurisdiction upon the basis of the rules of the convention where possible. And then it goes on to the conclusion. And what we say about that is that in contrast to the position where a child is habitually resident in a contracting state, so the complete and closed system, nothing prevents the use of an authority of a contracting state exercising domestic jurisdiction. And note the words where possible. So in other words, coming back to my example of the child who wants to go abroad for a holiday, it may be to that child's advantage for the interim care order, for instance, to be packaged as an Article 11 measure so that it is recognised abroad.
I mean, that would depend on the domestic law, because under the Family Law Act, it does set out that the you first look at the Hague Convention.
Yes.
And Baroness Hale in A, was it, said the first port of call is the regulation.
Yes.
I think it was a regulation case, wasn't it?
Yes.
So the domestic approach might be the first port of call is, let's look at the convention. Do we have jurisdiction under the convention? If we don't, we go to domestic rules.
Yes.
As a structure.
Yes.
And that's what I think Mr. Setright was submitting. Would you disagree with that?
No, I don't disagree with that. I should really move on from the Family Law Act of 1986 because I think it's such a tricky.
No,
fix.
I'm just saying, because the submissions that are being made in this case, you don't want the public law and private law to be completely disjointed.
No.
And the private law under the Family Law Act seems to require first port of call, as I saying, the convention.
In most situations, but not interestingly, although quite what is meant by this omission, not in the case of special guardianship applications. It's a curious, probably a bit late in the day to be turning to the technicalities of the 86 Act, but just
Where is
so it's page. Page 16, my lords. Jurisdiction, and if one looks at 2A,
right.
there's no. That's why we said.
So that goes straight to section 3.
It's interesting. 2B perhaps needs no explanation beyond the fact that Hague excludes matters pertaining to adoption or preparation for adoption, so one can understand that. In special guardianship, it's interesting that that doesn't occur. There it is. I think just in relation to, I think finally, anomalies on the appellant's case, the situation, for instance, under Article 6 pertaining to refugee children. So these are refugee children who cannot go back to their state of habitual residence. Simply make this point that if a child is in all but name a refugee, so for instance, has fled the country of its habitual residence, but is a national of this state and come back here, then strictly speaking, would not be a refugee, but would be suffering the same risk of persecution as a non-national. Article 6 of the Convention, as it happens, gives the convention state a jurisdiction over the non-national, because the non-national can be a refugee within the meaning of the 1951 Convention, but the national could not. And it cannot be right that we would discriminate in favour of a non-national and against a national. It cannot be right that a child fleeing persecution, for the same reasons, but simply being a national here, would find that we have no substantive jurisdiction. So there are anomalies. There may be other reasons why. So they may be fleeing persecution for reasons not covered by the 51 Convention. So you could have children in parlous situations who don't strictly come within Article 6, are not habitually resident, but similar children would qualify. So we just identify that anomaly. And I think finally we put in the provisions of the Adoption of Children Act, just to illustrate that at 32, that's page 32, my lady, my lord. So, for instance, Section 22 of the Adoption and Children Act, a local authority must apply for a placement order if a child, in the second part of subsection A, or is being provided with accommodation by them. So if the local authority is providing a child with accommodation, hasn't been authorised, no agency has been authorised to place the child, the authority considers the Section 31 criteria met and considers the child should be placed for adoption, then it must apply to the court. So there are circumstances, I appreciate infrequently used, but if a child is in local authority accommodation, therefore present here, statute does permit a route directly to adoption. And that adoption, of course, would not be recognised under the Hague Convention, but I suppose would be recognised under other conventions. So again, that's an anomaly that why should there be no jurisdiction for presence for the making of a care order where the court is looking at precisely the same terms under Section 31. Now, see if Mr. Lamb has anything he'd like me to add. My lady, my lords, unless there's anything else I can assist the court with, those are our submissions.
No, thank you very much indeed. Yes.
My lady, my lords,
Yeah.
I of course attend on behalf of H and H only. I'm not instructed on behalf of CAFCAS and all guardians everywhere, but by Miss Thorpe, who sits to my right and is very much concerned with H. May I just make some obvious points, perhaps? I highlighted it at the beginning of my skeleton argument. H, now 13 years and 7 months old. I have taken instructions from Miss Thorpe today, who is of the view that, although there hasn't been a formal assessment because it hasn't been necessary, likely to be competent. And of course we are in week 93 of these proceedings. The reason I make those points is because, of course, these, as interesting as these points are, and I mean, I don't mean that in any way disrespectfully, there is a child at the centre of all of this who I'm ashamed to say is still living in a foster placement with a suitcase half packed because of the uncertainty that this is bringing about. She was aware that this case was due to be heard at the beginning of this month and was made aware of the fact that there was going to be a delay in relation to that. From her perspective, there seems to be no end in sight. And we were grateful that was acknowledged by Mr Justice MacDonald in his judgment, that there was a child at the centre of all of this. But of course, it becomes really, in my submission and in this case, quite clear why it is that the court has to have in mind the child as it is at the point at which decisions are being considered and choices are being made about that child, rather than a version of that child who existed some considerable time earlier. I'm not going to be addressing you for very long. You've heard very lengthy arguments on both sides of this, and in so far as our response to the main appeal goes, we align with the local authority. So I don't purport to repeat. I could not impress upon what's been said to you by Mr Newey, and I wouldn't dare try. I approach this in a slightly different way. And if I may say, yes, there is an element of me coming back to this case with fresh eyes in the weeks of the 80s and the 90s. But I was in fact counsel for The Guardian at the first and second hearing in this case. I appeared before Her Honour Judge Sapnara on the 7th of September. I appeared before District Judge Orchover on the 20th of December, both dates in 2001. If I may say this much, there was no doubt in the mind of Her Honour Judge Sapnara about what she was being asked to do and the basis upon which she was doing it. That much is clear from the submissions that I made and the solicitor for the local authority made, and the order is in the bundle. Looking back at it, inelegantly expressed, I accept, and I have to take responsibility for that, but nevertheless, the basis upon which Her Honour Judge Sapnara was making the interim care order was clearly on the basis that there was nobody in the United Kingdom who had parental responsibility, and therefore we had was effectively an unaccompanied minor. An unaccompanied minor who was making serious allegations. I'm going to be very cautious about this because, of course, I don't want to say anything that may lead to identification. But on the 6th of September, Miss Thorpe had met with H. And there were a series of questions that H had for Miss Thorpe, very much centred around questions that she had about why she had been sent to the UK, and certainly around the allegations of potential threats to her life in Tunisia. As I say, I'm not going to go into any more detail than that. I don't think it would be appropriate to do so. So clearly, Judge Sapnara was aware that there was a need to act. It's seen in the recitals to the order. She finds the interim threshold crossed, in my submission rightly so. But what is abundantly clear from that order in paragraph 1 is that the issue of
Have you just got the reference to that, the page reference? That's sorry
yes,
to
it's in the
interrupt.
supplemental bundle. CMH paragraph, page 31.
Thank you.
The recitals on page 32. Yes, so recital D, on capital D on page 32, the last point. There is currently no one who is exercising parental responsibility on H's behalf. And that was a point that really loomed large in the mind of the local authority, the Guardian, and then ultimately the judge. But we were not proceeding on a basis of assuming jurisdiction, because, my lady, my lords, you'll see at paragraph 2 of the actual, it's under the heading next hearing, over the page on page 33. The very next hearing was being set down for the issue of jurisdiction to be addressed. The reason I make this point is that there is something in the appellant's case that would seem to suggest that we had been proceeding on a basis of assuming jurisdiction, but that simply wasn't the case. We were aware that it was a live issue, and the reason I raise this point is that the concept of jurisdiction being a live issue to care practitioners is not something that we are unfamiliar with. Right at the outset, judge and advocates, parties were all aware that this is something that had to be dealt with. The case is set down, and I think now, in retrospect, I have to concede that when that date came through, because that date was not given to us in court, that came through as a result of listing, finding the next available date in the diary. In retrospect, had I been shown that, I may well have said, I think we need to go back and ask for an earlier date, if at all possible.
Yep.
And it seems to me that if anything is to be gained from giving guidance, really the guidance is going to have to be, and I have to agree with my learned friends on this point, it needs to be dealt with quickly. Because if anything demonstrates what can happen, this case is it. I understand the anxiety of my learned friends in terms of the listing in the family court. It is incredibly pressurised. Frequently, we are receiving dates long into the future. Unfortunately, it may simply have to be that this is one of those issues which has to be dealt with on an urgent basis, if at all possible, and has to take precedence in the diary. It happens. If there was an application for an EPO, that would have to take precedence over other matters potentially in the diary. We currently have, certainly at the Central Family Court, what we are now calling legacy cases, whether that's a fair characterisation of what they are. They are the cases which are long overdue, largely as a result of COVID, and they take precedence over other cases in the diary. So it is not as though the court hasn't got some flexibility to be able to try and address that particular problem. As I say, in retrospect, having seen that date, perhaps steps should have been taken to bring it back.
I've forgotten the practice direction that's referred to in the skeleton that says 18 days. Which is that?
Which is the...
Practice direction. I thought there was said to be a practice direction somewhere in it says...
Yes,
Relation to abduction.
Was that habitual resident? What was
PLO
that?
outline, my lord.
Sorry?
The PLO outline.
Oh,
It's the PLO outline,
right.
not PD. I got that wrong. Do we have the PLO outline in the red book? Is it in the red book or not?
Oh, well, I'm corrected. PD 12A.
PD 12.
But it has the public law outline.
But incorporating that. So
Oh, okay.
our reference is in paragraph 40. A footnote on page of paragraph 40 of our skeleton.
Sorry, paragraph.
Footnote of paragraph 40.
PD 12A to the FPR 2010. So that's...
Yep.
That is
Which
the
paragraph is it in PD 12A?
Oh, that I can't help with, but it will be in the red book. Your lordship is absolutely right.
So
Requires the
somewhere
court-
in this it says that you should have a...
Requires the court to consider jurisdiction in a case with an international element no later than day 18 after issue.
That's
Right.
it. Thank you.
Do it.
clearly in this case honoured in the breach, and would not have been. If I may say, at this point, of course, what we have from the president of the family division is a directive to be more in keeping with the PLO than perhaps cases have been in recent times.
It's been relaunched, hasn't it, the PLO?
Yes, and if certainly experience at the coalface would suggest local authorities very much taking that on board. Frequently, applications coming before the court with the necessary reports, etc., ready to go. Clearly, this point not necessarily having been picked up, but can be, and made clear to others. I align with my learning friend for the local authority that what we experience, or what we are likely to experience in care cases where this particular issue arises, is going to be a lack of evidence or a lack of reliable evidence. And that's exactly what happened in this particular case. Her Honour Judge Sapnara set up the case to be determined with as much evidence as could be reasonably obtained in advance of that hearing. My position statement for the December hearing has made its way into the core bundle. What I highlight is, first of all, a concern that the local authority had, to use my phrase, cherry-picked parts of the evidence as available to it in order to pursue a case that H was not habitually resident in the UK, very much relying on things said about a potential return date at that time, but also a total lack of evidence from any of the relevant family members to whom the social worker had spoken. I can't accept the characterisation by the appellant that the local authority had dragged its heels and taken no steps to try and resolve this issue. That simply wasn't the case. I have checked my attendance note for the 20th of December hearing. The difficulty we had is that the appellant was aware of the hearing, indeed was without a device that would allow her to dial into the hearing, and the Central Family Court could not dial out to her because it was an international number and therefore was blocked. Even if we had been able to overcome those difficulties, there was no availability of an interpreter. So I don't accept that there had been a delay in notifying the appellant of that relevant hearing, because as far as we understood, she was effectively somewhere ready, willing and able, albeit with the obstacles that I've highlighted. But again, when we approached that hearing, no statements, no primary evidence of any of the assertions made by the various family members, and on the face of it, a conflict that needed to be resolved. Clearly, what was being said by H's uncle was at odds with what was being said by other family members. There was only one person who was going to be able to resolve that, and that was the judge. And the only way that the judge was going to be able to resolve it was on evidence. So, again, this case rather highlights the difficulty that the court's going to find itself in. What I say, of course, in my skeleton arguments, and I think I've laboured the point in my document, is that all takes time, but the child does not remain static. And ultimately, things move on. And that is exactly what happened for H. Over time, she settled and she started to make experiences in the UK. That perhaps could have been avoided if there had been more effort put into trying to get the relevant evidence at the relevant time. But ultimately, we were where we were on the 20th of December, with still more questions than answers. We had received the night before that hearing a document from the French authorities in French. Luckily, a solicitor within the local authority spoke enough French to tell us what it might mean, but it raised more questions about the grandmother. It raised more questions about what H's nationality actually was. There was a question as to whether or not she in fact had French citizenship. All again had to be resolved. The document that I prepared, and I suppose I really came at it from a slightly different perspective. So I'm not going to repeat what's been said by my learned friends. I came at it from the point of view of, insofar as Mrs Justice Leaven takes apart and criticises the approach of Mr Justice MacDonald, I wondered what he might have said had he had a right of reply and tried to address some of the issues as raised, focusing on how practically the care practitioners in this country are likely to approach the issues that Mrs Justice Leaven raises. I don't propose to go through them because they're in my document, but unless there is something in particular that you would wish me to elaborate on, I think it's all there. What I'm effectively saying to the court is I understand the anxiety, but it's manageable. And in reality, it's no different, for example, than where the court might make an interim care order. The child may vote with their feet. The local authority may choose to take no steps in relation to that. So at the next hearing, there is a reassessment, potentially with a discharge of that interim care order. There is the idea that something stays static at one point but can't be reassessed is actually quite alien to care proceedings. And from the Guardian's perspective, having a watching brief to consider whether or not things have changed is not problematic. Those are fundamentally my submissions on the point, unless I can assist you any further on that.
Anything? No, thank you very much indeed, and I'm grateful for the Guardian's attendance. Anything in reply, Mr Setright?
Yes, bullet points, really, my lady and my lords. First, from my learned friend for age. He slightly misunderstands our submission. I think I said in opening that the local authority was on to the issue of jurisdiction commendably quickly. And it was raised. The difficulty was the length of time it took for any resolution to be reached. Second, my learned friend's characterization, based, of course, on his own account of what he professionally thought and said, a counterbalance of the issue on habitual residence. A counterbalance to that is in the main bundle at page 126, and it's the authentic skeleton of the local authority for the December hearing, which was meant to be on.
Is that the supplementary bundle?
I think it's in the main bundle among the skeletons presented there. I'm open to correction.
It is.
Core bundle, yes.
For the December hearing.
For the December hearing.
Excuse me.
And it's in, is that the bundle? 126, bundle page 126. And my lady and my lords will see a very firm dissection of the position on habitual residence based on evidence, asserting a short trip to the UK only was intended, time with uncle was absent stability of any sort. This was a very, very firm position, rooted in the facts. If there was a view taken by, on behalf of the child at that point, that was, I suspect, a bit of an outlier, though that doesn't mean there wasn't an issue. Such things are capable of rapid, robust resolution. Mr Justice MacDonald, in his judgment, reflects the likelihood of the situation. The local authority concedes it. It is likely that if there had been a timely determination of habitual residence, it would have been not here, but in Tunisia. The difficulty is not that the issue was not identified by the court and the parties. It most certainly was. The difficulty was, one, it was not grappled with, and two, the issue of jurisdiction on an interlocutory basis. If one talks about interlocutory as being a period before there's an adjudication on habitual residence, which is the first point of entry, there wasn't an indication by recitals and orders as to what jurisdiction was being exercised. We are not remotely, again, perhaps my learned friend slightly misunderstands, we're not saying that there wasn't material for an interim care order. And there was. We're not saying that emergency provision was inappropriate. Plainly it was. But there wasn't an eye to speedy resolution and to jurisdiction. So those were points that arise out of my learned friend's suggestion. Looking at my learned friend, Mr Toomey, and taking them in no particular order, he raised a question, well, what would happen if an English national found her or his way here, couldn't claim to be a refugee because there was nationality status? There would be no habitual residence. There would have been an escape from a country of habitual residence. What would be the jurisdiction? Would there be limbo? Well, there is a parens patriae jurisdiction, which has an unequivocal basis because it's been explored by the Supreme Court. And a parens patriae jurisdiction is, of course, available in exactly the situation, if there is no other, that my learned friend postulates. That, however, is probably a sideways comment, and it's of very little assistance to the court in resolving these appeals. Let me see if I can come to points that may be arising out of my learned friend, Mr Toomey. He spent time looking at the 1996 Hague Convention Practice Guide, the Lagarde Report, and he also went to the CJEU case, which is, of course, of interest, that case was published after the hearing before Mr Justice MacDonald, the first hearing, if I can call it that. It was published before the hearing before Mrs Justice Leven, but doesn't seem to have been referred to. In the skeleton for this appeal, we thought it appropriate to mention it, although it doesn't assist us, we think, because it was necessary for completeness. What we say about that decision is it is, again, one which relates to an apportionment of jurisdiction following a leaving of a Brussels to a country, to a non-Brussels to a country, in the midst of proceedings. It covers the same territory as the practice guide and to the 96. The focus is what happens when you leave a jurisdiction. That was the principle in that. We say that it is probably not controversial and probably won't give this court any difficulty at all either, that if there is a change of habitual residence, then there is a jurisdiction conferred on the new state of habitual residence, and it's conferred when that habitual residence is established. That's not rocket science, with great respect to everybody, because it's the same situation that is examined day in, day out when looking at the inception of proceedings. Is there habitual residence? One doesn't, because 1996 is it doesn't have a perpetuatio fori provision. One doesn't say, oh, well, we'd better wait, we'd better hold on, because there might one day be an habitual residence. That would be unconscionable and improper when one is looking at a need for proceedings now. So it is my Lord's retrospectivity point that my Lord raised in respect of civil proceedings, if I roll up the argument together. And our first line of submission, which was rapidly followed after my lady's intervention by our second, more emollient fallback position, was based on exactly that purist approach, which is to say, if you don't have a jurisdiction, you don't have a jurisdiction, and therefore you don't have proceedings. If the basis of your proceedings is invalid, they should be discharged. If you only discover 6 weeks, 6 months, 11 months into the proceedings that there is no valid basis, your proceedings are discharged. That's a purist approach. What it should defer to is the availability of emergency measures.
Sorry, you're about to finish a submission, aren't you? Because I have a question about
If
the
my
first
Lord
part.
asks it now, I'll cope with it.
No, I don't want you to forget. I didn't mean to interrupt you. No, go on. Can finish what you're going to say.
There is available emergency.
Yes, there is an emergency jurisdiction, and that may complicate the picture that my Lord painted and that I sought to paint in our first position. And it may make attractive the fallback position that if there are, for a more limited purpose, or a more limited primary purpose, Children Act proceedings, then those proceedings exist. Where we take issue quite strongly with my learned friend's characterisation of our case is that it was put that we are asserting that with the protective measures, a child can simply be parked in this country in a sort of limbo. Far from it. The protective measures are meant to cover emergencies. They may subsist for some time, but they are in character emergency measures. They won't place the child in a limbo. The child will be covered by emergency provisions. In the meantime, one reasonably expects a high degree of activity. For example, one would indeed expect consideration of measures to repatriate the child to the country of habitual residence, whether under Article 11 or by a private application for a non-convention return, to be made. And if not, the question might be asked, well, why not? A judge who has charge of the case with the emergency measures would be expected, in accordance with the fact that this is an emergency, to run it exceptionally rigorously to avoid such a limbo. But, my lady and my lords, we say that where the local authority may have fallen into understandable error is that there are two completely different concepts in play. One is the transfer of jurisdiction and the principles related thereto, which are dealt with in Article 5 and form part of a very important scheme which is meant to be of universal application based on the 1996, which we in this country endorse. The other is the purely domestic matter of ensuring that proceedings are instituted on a valid and definite basis. There is not necessarily a nexus between the two. The issue in this case was there a jurisdiction? And if so, what was it on the 18th of August? If on that date there was not habitual residence, then there might have been no jurisdiction, there might have been an emergency jurisdiction, be it under Article 11 or under the Children Act, or there might have been, on the election of the judge, some manifestation of the residual jurisdiction. But that needed to be ruled upon. If subsequently there was an acquisition of habitual residence in this country, that has absolutely nothing to do with, and certainly doesn't derogate from, that need. That's the case in a nutshell. If there's a change of habitual residence, I know that my learned friend who says he appears directly for the child, he corrected me by saying that he was for the Kafka's guardian. I think he says he's not. And he said he wasn't speaking on behalf of guardians. But then in his submission he said, who better than the guardian to carry the burden of monitoring the position on habitual residence?
Seems all right to me.
I might suggest, my lady, that the court, which was what he then went to, or the local authority, might in those circumstances be likely to be vigilant and well informed, and the point would be raised. I suspect that there won't be a difficulty, a practical difficulty, in raising the point when it is appropriate. But in the meantime, until it is raised, there simply must be a regular basis. And my lady and my lords, Mr. Toomey's submissions, which were careful in large measure and in large measure sensible, went a long way.
I'm sure he'd be very grateful.
Went a long way. I was very grateful.
I focused
Went
on
a
the
long
large
way.
measure.
went a long way to conceding that case that I've just articulated in his.
I think you both made sensible, well, concessions or near concessions.
Oh, I've been reluctant, my lady. But the certainly on ground two. So, my lady, that I think. Let me see if I may have a moment.
Of
Can
course,
I ask
please.
the question I was going to
Oh,
ask?
yes, of course.
Because Mr Justice MacDonald decided that H is habitually resident here. So, does this court now have substantive jurisdiction, or was he right that as at the 7th November, 19th December, the court had substantive jurisdiction based on habitual residence?
If it depends on whether the process is correct, but if if Mr Justice MacDonald says, as he does, that as at the date that he determined the case before him, there was habitual residence, then there is, of course, a strong argument that one way or another there is an habitual residence-based jurisdiction, one way or another. But it remains unsatisfactory, particularly from the point of view of H and from the point of view of the grandmother, because of all the detriments which I've explored this morning with the court, which resulted from what we say was a wrong in law, as well as bad in policy, approach to the determination of the issue. And when I say one way or another, that might entail the discharge of the original proceedings, or it might entail following a judgment which we, with respect, didn't get from Mr Justice MacDonald, an analysis of what the original proceedings were, what they were based on. Were they based on physical presence? Were they based on an emergency jurisdiction? What were they based on? Revising that to, as it were, beef them up with an habitual residence element. But we say that the decision of itself was wrong. It was wrong because Mr Justice MacDonald should have asked the question, where was habitual residence on the 18th of August?
I understand that, but he also has to ask, because everybody seems to agree, that if habitual residence moves during the course, even during the course of proceedings, jurisdiction moves. So if England and Wales has acquired jurisdiction, and that's why the CJU decision is interesting, because it says the same. If England and Wales acquires jurisdiction in the course of proceedings, it has jurisdiction. So it's not one date only. It's yes, you have to determine whether you have jurisdiction robustly right at the outset, and if you don't, then you need to act accordingly. If there's a doubt about it, you need to, etc. But we can't, I think I might have said, tonight was it not in my own mind, we can't rewrite history. So that I understand your concerns about the progress of the proceedings in this case, but looking at his decision as to habitual residence is not quite rightly challenged. So this court now has, the court had jurisdiction, has jurisdiction. That's why the care proceedings have not been stayed.
We, my lord, hopefully have made clear that our case is that the right approach to the determination of jurisdiction is to determine it at the relevant date, and then if there's a change, to reconsider matters when that change is made.
Right.
I mean, you're really not very far apart, because what I think both everyone accepts, or the Guardian, is that the judge was not wrong in saying that he had to determine or consider where habitual resident was at the date of the determination, because there was involved the change. What your complaint is, Mr Setright, is that he started at the wrong end. He looked down the wrong end of the telescope, because what he should have done was say, you make your initial determination very quickly, right at the beginning, and you say on what basis that you have it, and act accordingly. And you say, had that been the correct starting point, this grandmother would not have been prejudiced by the delay in the way you say she was.
And age.
And
depending on the way one looks at it.
Depending on the way one looks at it. And so, but that he wasn't wrong at the end of the day in saying on the day he had to make the decision, he had to consider whether the jurisdiction remained, and it on the same basis, and it didn't, because there'd been a change.
He asked the right question, but at the wrong time, as it were, in terms of the obligations of the court.
Well, really what you're saying is you consider jurisdiction right at the beginning. I won't go through all that one again, but you do. But of course, every court because things are not static, has to be conscious of whether or not the position has changed. And if it has, to deal with it accordingly. And he did.
It is, however, a lady, not something that is without consequence and significance. So it's not.
I hope I've just
yes,
indicated that
not
I understand that.
It's not an arid point that is brought before this court, although it is one that needs resolution.
Well, my lord gave permission on that basis.
Precisely. But if Mr Justice MacDonald, even having, which we say is really an abuse of the process to determine habitual residence 11 months after the proceedings had started, if he nonetheless did that, he should have made a determination of what the position was as of the...
It shouldn't have been the first time it was done.
Yeah, but...
That's the point, isn't it?
Therefore, even now, there may be a different approach if it is acknowledged that first the matter should have been evaluated as of the 18th of August, even if the evaluation took place in, say, September or December. And then we suggest, and your ladyship and my lords have seen the reference to the local authority's skeleton in December, it's quite likely that if this had been decided in December, habitual residence still wouldn't have been here, that there would be a different approach. There might then be a different
You'd
approach.
still have had a 13-year-old Gillick competent child that was saying she wasn't going anywhere.
May I have a moment? Because I think my learned junior was whispering something. Oh, yes. Yes. What Miss Guhar reminds me, and it's in our skeleton because we set out the progression, is that her views have changed. And that may have been for all sorts of reasons.
Which we can't
I'm not
possibly
sure it's
explore.
helpful for me
No.
to explore those at this
No,
point.
but the court still is now required to make a welfare decision, which I hope I hope the proceedings are continuing to welfare. Are they?
They are.
They are.
You were
Your
going
Lordship-
to tell us where we'd got to.
Oh yes, I am. Your Lordship directed that there shouldn't be a hold-up
Yes.
in those proceedings. And shall I give the court a very brief summary of
Yes,
what our
Yes.
position
Yes,
is?
please.
Contact's been taking place every 2 weeks. Joined, that's between the H and the grandmother, and has been going well. Other Tunisian family members have joined in the contact. The most recent one was on the 22nd of May with the paternal grandmother, and I knew she would appear, H's aunt and cousin.
She does exist then.
Absolutely, I wouldn't dream of fabricating someone, and lasted 40 minutes, which was 10 minutes longer than the usual time, so happily there does appear to be relatively good interaction. No progress thus far, though I can correct that as to something that's happened today, has been made in terms of a parenting assessment of the paternal grandmother. It was agreed that any assessment would be undertaken in Tunisia, but the scope of the assessment wasn't addressed or hasn't to date been addressed. Whether it should be an SGO, there we are, the reference to special guardianship orders may be relevant, or a kinship assessment or something more limited regarding the ability of the family to care for the children. It is not yet determined. There had been an independent social worker who spoke French, who'd been identified, but he said on the 28th of April he couldn't undertake the assessment because there is, unfortunately, currently government advice, our government, against travel to Tunisia. And the grandmother continues to say there should be an assessment in person. I'm glad to say that a well-known independent social worker has now been identified who is a French speaker, and I understand that all parties are agreed that that person should go and carry out the assessment. So that is that.
Thank you
I
very
don't
much.
think I'll name him because there's no particular purpose in naming
No.
him. but
No,
everyone
I
knows
think
who he
that's
is.
fine.
Additionally, an application was made yesterday, I think, by the local authority for a psychological assessment of age, and the paternal grandmother doesn't oppose the application, but at the moment we don't know, we don't have experience of the proposed expert, so that's.
But it looks
business
like that's going
underway.
to.
This court doesn't need to be concerned
No.
with
But-
details of that kind.
Thank you. Well, that's reassuring that, as requested by my Lord
So
Justice
that
Moylan,
is-
things are at least progressing.
That is what is happening
Thank you.
on the ground. May I have a moment to see whether there is anything else
Of course you may.
that I should
Yes.
trouble the court with? My hands. Thank you. Anything else you wanted to? Oh yes. Two matters, if
Certainly,
I may,
Mr.
just two. From those instructing me,
Yes.
the suggestion that was made that the grandmother didn't really do anything. Not the suggestion by my lord, but it came from the bar in the submissions this afternoon. The grandmother, having indicated her desire to be involved, was, as a French and Arabic speaker in Tunisia, and not the most technically proficient of persons. And in that, not in where she is in Tunisia, but in her general disposition and demeanour, not untypical of parents and grandparents who become involved in public law cases, she did actually require a great deal of assistance to, for example, secure representation.
I'm quite understand.
And it was not, most regrettably, done efficiently. And so, notwithstanding what is said by my learned friends, I've corrected my learned friend for the child on one matter. We do say that the issue of habitual residence and jurisdiction was identified rapidly, although not acted on in practice rapidly. We don't accept that the grandmother sat on her chair and did nothing. We do say that there was a responsibility to help her, imposed eventually by the court, and not met with adequate speed.
You said there were two things.
The final point, lady, is that I remind myself of paragraph 16 of, I think it is, of Mr Justice MacDonald's judgment, where he did say that things would have been different, and that difference relates to the, we suggest, the forum application which he determined, and perhaps the summary return application which he determined, if he'd reached a different answer, or answer at a different date, on habitual residence. Whether that makes a difference now is, of course, another matter, but it certainly would have made a difference. But that, I think, is a point my lady and my lords had very much in mind.
What paragraph was that again?
16.
60.
Oh, sorry.
60.
I thought you said 16.
No, page 413.
Thank you.
So, unless there's anything else, those
No,
are-
thank you very much indeed. We're very grateful to you all.
I would say this, that if my learned friend is going to make some written submissions on the particular point
I don't think we need. Do you want to hear it?
I've now forgotten what it
It
was.
was about. It was about. I think we've effectively dealt with it, haven't we?
I think it was not necessarily entirely relevant to this appeal.
No.
It was about proceedings issued without subsequently discovering issued without jurisdiction.
Yes.
Any jurisdiction at all.
Yes.
And where that would
Not
leave.
this case.
But if you have any sparkling, as can you discuss it with Mr. Setright? And if
Yes.
together you can come up with something you think would be helpful in one page, yes, please, but not otherwise.
I'm very grateful. Thank you very much.
I'm very grateful for that. I rose simply to make sure that we had a part in it.
Of course.
But it may not be necessary with respect. Thank you, my lady.
Thank you. Well, can I thank you all very much indeed, not just those on the front row, but also Junior Counsel and its solicitors, and of course the Guardian for her role in all of this. You won't be surprised to hear that we will be reserving our judgments. I make no promises at all when we will be able to send you a draft. As you're aware, this is has wider ramifications than age. Fortunately, as you've been able to explain to us a moment ago, Mr. Setright, the care proceedings are now no longer stalled and are proceeding, it would seem, at a reasonable pace, notwithstanding the terrible delay that there has been up until now. Of course, we would anticipate, and if needs be, it can be communicated to the judge dealing with the matter, that we fully expect the care proceedings to carry on in the normal way without the necessity of having our judgments. The judgments will be set, draft judgments will be sent in the normal way to each of you. That's for in draft for typographical, minor grammatical or ethnicities. Not an opportunity to re-argue the case, please. I'd hope thereafter you can agree any orders in writing. And I just remind you, though, I think everyone's more or less used to it now, of the new terms of the embargo, which you'll find at the top of our draft, and that we will require a list. Unless there's anything else that we can deal with today, I'll just say I'm very grateful to you, and 20 past 4, excellent. Thank you all very much indeed.
All right.